Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Aaron Asiedu Entry, and today we are looking at why the suspension of the Chief Justice by President Mahama is unconstitutional. Why the suspension of the Chief Justice by President Mahama is unconstitutional. This video is proudly sponsored by Vian's Groceries. They are located at the Paraku link, and you can contact them for any sort of groceries you need. Their numbers are on the screen. Now to the main subject, why the suspension of the Chief Justice by the President is unconstitutional. Now let me state this. My position or this editorial clearly is based on law and nothing sentimental or say political. Now the point here is that the President communicated to us some months or some few weeks back telling us that he's received some petitions. In fact, it was 3 petitions he mentioned, and he has forwarded same to the Council of State for them to help establish a prima facie case. Indeed, we heard the Chief Justice also requesting copies of the petition so that he will be able to contribute to the Council of State in making a prima facie case. President Mahama, upon receiving the letter from the Chief Justice, of which the Chief Justice was asking for 7 days, he graciously granted her 10 days to bring her response. The response went, and we heard in subsequent weeks that the Council of State, together with the President as the Constitution, or the case of Frank Ejechum and Attorney General demands, have established a prima facie case, and as such, the President suspended the Chief Justice based on Article 146, Clause 10 of the Constitution, which clearly depicts a discretionary power. Now, my argument today is premised on what Mr. Nana Bafuwa, Member of Parliament for the Good People of Menchia South, and also the Ghana Bar Association is espousing. And I'm going to explain to the best of my ability and knowledge as to why I also agree with their position and believe in same that the suspension of the Chief Justice is unconstitutional. Now, the point here is that if you are reading Article 146 Clause 10, it reads, where a petition has been referred to a committee under this article, the President may, in the case of the Chief Justice, that is A, paragraph A, in the case of the Chief Justice acting in accordance with the advice of the Council of State by warrant signed by him, suspend the Chief Justice, and B, in the case of any other justice of the Superior Court or a chairman of a regional tribunal acting in accordance with advice of the Judicial Council, suspend that justice or that chairman of a regional tribunal. Now, the point here I'm trying to make you understand is that the word may ordinarily in law means that there is a discretion, and where discretion means that there is an option for you to either act or not to act. You either act or not to act. Now, the point is, this discretionary power is likely to be abused by any other person who is in power, or such discretionary power is bestowed on that person. I am not limiting it to the President alone. It can be a Minister of State, it can be a Member of Parliament, it can be an Electoral Commissioner, or whosoever the Constitution bestows a discretionary power on. The Constitution, or the framers of the Constitution in their own wisdom, believing in what Lord Acton once said, that power corrupts and absolute power corrupts absolutely, has given us, or has placed in the Constitution, an inbuilt mechanism to regulate discretionary power. And this inbuilt mechanism can clearly be found in Article 296 of the Constitution. And if I may read Article 296 to you, it says that where in this Constitution or in any other law, discretionary power is vested in any person or authority, A. That discretionary power shall be deemed to imply a duty to be fair and candid. B. The exercise of the discretionary power shall not be arbitrary, capricious, or biased, either by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. Now, where I build my case on is Article 296, paragraph C, and in law we will say emphasis mine. It reads, where the person or authority is not a judge or other judicial officer, there shall be published by constitutional instrument or statutory instrument regulations that are not inconsistent with the provisions of this constitution or that law to govern the exercise of the discretionary power. And so, if you are exercising discretionary power under this constitution, you must comply with Article 296. And where you are not a judge or any other judicial officer, you are mandated by this constitution to have a constitutional instrument, a CI or a statutory instrument, or a regulation that is not inconsistent with any of the provisions of the constitution. Before I explain this better, the problem over here is discretionary power and why it is regulated. Now, my constitutional law lecturer, Dr. Justice Shremsai, who happens to be the incumbent deputy AG, taught me under evolutions of constitution that at every point in time, you must look for the spirit and behind the letter of the constitution. And he is right, because in the celebrated case of Tufo and Attorney General, where we had our former president Nana Dankwa Akufo-Addo together with lawyer Chachu Chekata and one other lawyer, being lawyers of the late Dr. Mwaku Tufo. In that case, the court, speaking through SOWA JSC as he then was, stated that the constitution has its letter and it equally has its spirit, and that the spirit entails our history, our aspirations, amongst others. So every provision of this Constitution 1992 has a reason or a history as to why that provision is existent in our Constitution. And today, let me take you down through memory lane. Somewhere 1963, there is this popular case called the 1963 treason trial, by which is popularly known as the Adamafiu case. The Adamafiu case. The case follows the Kulugungu bombing, which nearly took the life of our first president, Dr. Kwame Nkrumah, and after that, the state instituted an action against Mr. Adamafiu and some others, of which the court, which was empaneled and had some Chief Justice Akoko-Osah, William Larry Van, and also Akufo-Addo, acquitting Adamafiu and those who were arraigned before the court. Dr. Kwame Nkrumah, through a presidential order or whatsoever, suspended or dismissed the Chief Justice Akoko-Osah, Justice Akufo-Addo, and I believe William Van Larry. Now, the Justice Akufo-Addo in this picture is, your guess is good, is as good as mine, is the father of former President Akufo-Addo. Now, the people of Ghana became concerned on how power was being used arbitrarily, and as such, when the country came back under another constitutional rule under 1969, the framers of the Constitution through 69, 79, and now 1992 thought of putting in an inbuilt mechanism to regulate discretionary power. So we don't want to visit our dark days that one day a president or whoever will just wake up in the morning and suspend a chief justice or a justice of the Supreme Court. So Article 296 Clause C is telling us that if you are not a judge or you are not any other judicial officer, you need a constitutional instrument. But thankfully, case law has emerged as we moved on. In the case of Ransford France versus the Attorney General, the venerable Professor Dateba JSC, as he then was, ruled in that case that when we talk of constitutional instrument or a statutory instrument needed in the exercise of discretionary power, we cannot demand of that CI or SI at every point in time, else we are going to ground government. Because a minister wakes up, goes to his office, he's passing or making some discretionary orders and others, and he wants the minister should be going round to parliament looking for a CI to now regulate the process. It is going to slow down government. Professor Dateba, in that case, referenced Justice Ekufuado or Chief Justice Ekufuado in the celebrated case of Captain versus the Republic. And as such, in that case, the Ekufuado JSC made it aware that in a quasi-judicial process, you need a CI. In a quasi-judicial process. That reasoning was adopted by Professor Dateba, and he clearly stated that even though you do not need a CI in all instances, when it comes to a quasi-judicial process, you need a CI. A quasi-judicial process where you are adjudicating. In fact, that is what he said. You need a process. Now, the point is, let's read Article 146, Clause 10 again to know whether the president is acting in a quasi-judicial process. To me, the entire Article 146 process is a quasi-judicial process because you are taking someone, Council of State is going to make a determination on a prima facie case. There is going to be a committee to establish or go through the full rigors of the case to check whether the person, the Chief Justice or any other justice of the Superior Court has committed any offense. I guess you have already watched my video with my very good brother, Julius Kwame Anthony, where we explain Article 146 into detail. You can check it out on the Law Lab, where Julius Kwame Anthony did a very good work on that. He actually took us through all the grounds that a Chief Justice or a Justice of the Superior Court would commit or do for it to warrant his or her dismissal. Now, back to the point. The president suspending the Chief Justice is the president acting in a quasi-judicial process where the president is adjudicating. A simple research into the Black's Law Dictionary will tell you that an adjudication includes a reasoning, a decision, or a judgment. Now, the point over here is that when you read Article 146, Clause 10, it says, where a petition has been referred to the committee under this article, the president may, in the case of the Chief Justice, acting in accordance with the advice of the Council of State. So the president must act in accordance with the advice of the Council of State. But the Supreme Court has settled the question on advice in the case of Ghana Bar Association versus the Attorney General, where the Supreme Court said that an advice is an advice, it is not binding on the president. So even when the Council of State advises the president that go ahead and suspend the Chief Justice or do not suspend her, it is to the president to take a decision as to whether to suspend the Chief Justice or not. And that makes it clear that the advice by the Council of State is not binding. And so the president takes a decision. So if the president is taking a decision, then it means that the president is adjudicating. And we all agree to the point that Article 146 entirely is a quasi-judicial process. So in this present instance, President Mahama needed a CI or a statutory instrument before he would be able to have suspended the Chief Justice. Now, my argument is even further advanced in the point that the Chief Justice is appointed by the President, and the Chief Justice formally receives the blessings of the people in Parliament. And so the Chief Justice, whoever occupies it, becomes the people's Chief Justice, because the President would only appoint you, the person. Say the President appoints my brother Julius Kwame Anthony as the Chief Justice. Julius must go to Parliament for Parliament to vet him and receive a parliamentary approval before he can act in the office as Chief Justice. So the appointment involves we the people, of which we speak through our representatives or the representatives of the people, that is Parliament. So if I am involved in the appointment of someone, why am I not involved in the suspension of that person or the dismissal of that person? It becomes problematic. The framers of the Constitution thought it wise that for us to make sure that the people are involved in the suspension or further dismissal of that person, then you need a CI. How does the CI involve the person? You need a CI because the president would have to now go to the people's representatives to get that CI. In that instance, you are involving the people who endorse the candidature or whatsoever of the said Chief Justice. So when you get the CI, you have involved the people. So not getting the CI makes the suspension of the Chief Justice, to me, unconstitutional. Now, the point is, I'm not here to discuss any petition or response in the media, because I have so much trust in the presidency that have assured us that they have not leaked any document to the public. I believe that a leaked document is a document that an original is with someone and its copy or duplicate of same has now been found in the public. The presidency has assured us that there is no leakage of such documents, and as such, I will restrict myself to this. The process to me has gone on smoothly, but for the suspension of the Chief Justice. Clearly, Article 296, Clause C tells us that the president is not a judge, is not any other judicial officer, and as such, needed a CI. Ransford France versus Attorney General's case bears us out that even though the Venerable Professor Dateba, JSC as he then was, made us aware that it is not in every instance that you need a CI. However, he created an exception that in a quasi-judicial process where one is adjudicated, you need a CI. And in this clear case, President Mahama is adjudicating because the advice of the Council of State is not binding on him. And as such, he made a decision. And Black Law's Dictionary is telling us that an adjudication includes a decision, a ruling, a reasoning of the court or whatsoever. And so, you should clearly get that in this present instance, President Mahama made a decision, and that decision, not being on the back of a constitutional instrument, is unconstitutional. Thank you very much, and I believe that I've been able to explain my position very well. You can leave a comment on as to where you believe or you disagree with me. That is how we engage and build a country. We encourage healthy conversations and healthy discussions. Get to know that this video was proudly sponsored by Vian's Groceries, and I'm encouraging you that you patronize them. Their contact is on the screen. You can contact them at every point. They are at Paraku in Dome. At any point in time, they can deliver or dispatch any grocery you want. Remember, do not leave all your matters to God. Take some to your lawyer. This has been the Law Lab. Thank you.